You got a tattoo on your forehead.
They were running a contest where the first listener to tattoo the letters KRUD on their forehead would win a $250,000 prize.
All right, so we have a situation where a radio show decides to run a contest, and they're saying, do this thing, get a tattoo, put it on your forehead, you get paid $250,000, whoever does it first. Now, apparently on their website, they had this little hyperlinked, you got to read the terms of service. The contract just so happens that the contract, when someone clicked on it, it would show that this was a prank. Someone did not click on that. Is that legally enforceable? What's going to happen? Don't forget to subscribe. We are a law firm. We do a lot of business law, intellectual property, and we're here to help you with your business. Let's jump into it.
What happened?
I found out about this contest, if you'd like to call it that, from a friend that morning, and naturally I was a little skeptical. So what I did to cover all bases was I called the radio station and I spoke with a gentleman who identified himself as one of Cyrus's crew.
Okay.
And he did, in fact, confirm that this offer was legit. He also directed me to the contest page on the station's website. And the contest rules explained everything.
Okay, so before we even get to what was on this page, he goes, I was directed to the page, because I think that the defendants in this case are saying, no, we're clear about this, and had you just clicked on the button to see our terms, right? For our clients who have businesses, where I'll start is, for terms of service, what are terms of service?
Yeah, the terms of service are going to govern the relationship between the business and the consumer, whether that is somebody who's visiting your website, somebody who is actually using your product. It determines what they're going to get out of it, and then what your company is protected and what your limits are.
In other words, it's the contract for all businesses. You need to have a terms of service and usually a privacy policy as well. But the terms of service governs. If someone uses your website, what can they do or not do? Can they use your trademark? Can they download stuff of your website? Can they reverse engineer your software? And then beyond that, just if they're buying something from you, services, goods, if you don't have an agreement, right, directly with the customer, the terms of service govern that. So that's a little bit of what the argument is here, just saying that, well, we had a contract on the website, so to speak, but let's keep going, because if they're going to live and die by this, let's see what the argument is.
So it says, 3 easy steps to win a fortune. Number 1, take our call letters, KRUD. Number 2, tattoo them across your forehead, which is what you did.
Yes, sir.
Be the first listener to do it and win $250,000.
Yes, sir.
Does this constitute a contract? Well, and even let's back up. Is it an offer in that 1, you take the call letters, 2, you tattoo them across your forehead, and 3, be the first listener to do it and you get $250,000? Is that a contract?
Yeah, just on those terms, that's pretty straightforward. Both sides are getting something out of the contract. We saw there's a little bit on the bottom, some fine print that we're going to get into in a second. But if we're ignoring that fine print, that does look like a contract, and that could be upheld in court.
Yeah, and general rule, friends, when it comes to contracts, you have an offer, acceptance, and consideration. So there's an offer, you get something, right? There's an acceptance in that someone will then go and do the thing that is being offered. And the consideration, to Josh's point as well, there's being a whole lot of money paid. So the defendants here are saying, but there was a little asterisk. Click here for official rules. Does this hold up? Because, well, to be fair, on all websites, you go to the very bottom of the website and there's a tiny little terms of service that's hyperlinked. Now, a lot of times on the checkout, some businesses will have you actually click a button and say, by purchasing this product, I agree to the terms of service, right? So it's an extra safeguard. And most of the time, terms of service are enforceable.
That simple. So as you can imagine, I didn't waste any time. I dashed down to the first tattoo parlor I could find that was near my house, and I asked for a rush job on the tattoo, which, by the way, was not cheap. It took a couple of hours for
And you got a tattoo on your forehead.
Yes, sir, I did. As soon as they were done, paid them up, dashed down to the radio station, and the people just looked at me. They glared at me in disbelief, almost like they weren't even aware that this was going on.
Okay.
They started pointing at me and laughing at me. Who does that, Your Honor? In a professional setting, who does that? They took out their phones and started taking pictures of me, probably posting it on social media.
One of the things I'll point out is that this guy really went in for it, because the degree of the size of that tattoo, because here's the thing, technically to be compliant, couldn't you have just written it real tiny? You know what I'm saying? If this was a serious thing. But he really went in for it. Again, neither here nor there. But the question is it reasonable, or was it reasonable for him to rely on this information? Because for me, I'm like, he said he wasn't sure. He was skeptical, and then he actually called and he spoke with someone. And so a representative, an authorized representative, was like, yeah, no, it's for reals. do it.
Yeah, and remember, this is reasonable as an objective standard. It's not what you as the business owner thinks is reasonable for your customer to have interpreted. This is ultimately going to be a judge determining, was it reasonable for the customer to have interpreted this?
Well, and then also, can a company be held liable for the acts of its staff? If it's an employee versus if it's a contractor. So if you have someone who seems to have authority on behalf of your company, this really matters. And this is why we get into, you need to have very clear contracts, because if someone went rogue and now is taking phone calls and leading people to believe this is totally serious, and now is, quite frankly, gotten your company in a case, in a lawsuit, do you have any legal recourse against that person? Because maybe you didn't authorize them. Do you see what I'm saying? So is there a difference with employees versus contractors on like perceived authority on behalf of the company?
Absolutely. You want to make sure that the agent who is acting on behalf of the business is actually authorized to do so. This is where the business is going to be held liable for the agent's actions.
Eventually, after I was standing there for about 10 minutes, a representative came down from the studio and explained to me that this was, quote unquote, a big misunderstanding. He didn't say a prank. He said a big misunderstanding.
Okay.
And that there was no prize money to be won for me.
I mean, we get up to some crazy stuff, but I could have never imagined in a million years somebody would have actually tattooed our station letters to their forehead.
$250,000 is a lot of money. There are a lot of folks that would do that, right?
Seriously.
The judge makes a good point. $250,000. What would someone do for that amount of money? And all of this is just so ancillary to contracts where you may have accidentally, right? You may have accidentally and not even intended to, because in this case, it was just a big joke. Again, setting aside, was it reasonable for him? Was it nice of them to do that? All of that. Was an actual agreement formed, even accidentally?
Yeah, and to your point earlier, $250,000 being a lot of money, that might make it reasonable to assume that they're actually doing this for something as extreme as getting the tattoo.
Your Honor, he clearly did not read the rules. I mean, come on, if he would have went to the webpage, it would have clearly said, there was a link on there that said official rules. See the link right there? If he would have clicked on that link, the link would have took him to the page that said April Fools.
Now, did you see that
I
link?
certainly did not see that, Your Honor. And I have vision problems in both my two eyes. I can't see something that small.
He did not read the rules. Does it work if you go and you sign a contract, let's say at Verizon Wireless for your new phone, and this is what they have you do, by the way. You check out, you pay, and there's a button. You accept. That's where you accept the contract terms. And are you going to sit there and read the contract? Do they even give it to you in a way that you can read it? The answer is no, 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 no. But is this legally still enforceable? Other things you guys need to think about is in the contracts, oftentimes, key language is put at the very beginning of the contract, right? So in terms of service, and it's because they just don't want arguments that you didn't read it, so therefore you didn't know, because sometimes that's a way to invalidate an agreement, such as terms of service. So again, they go, well, there was a contract. And if you would have gone and clicked the link, you would have seen the rules were that this was just a joke and we weren't actually going to do it. Is that enough to save them?
Yeah, it sounds like what they're trying to do is incorporate that into this little contract that they have with these 3 steps. And when you're incorporating something into a contract, you need to be very careful and to make sure that it actually is a part of the contract and how it's a part of the contract, right? So we'll see this a lot with terms of service, having the privacy policy incorporated in, and that's something that you want to protect yourself. But in this case, was it actually incorporated into the agreement, or is it something that was just a separate aside? This is even before we get to the point of him actually being able to read it and his complaint about his eyes.
So this haha, we got you April Fools from the whole crazy crew at KRUD Radio is what he would have seen had he clicked on that link.
Absolutely. You know what? What we've heard today is someone who was rushed and ready to win some money, and he didn't take the necessary steps to protect himself when he could have just followed the link. He heard from a friend about this contest.
I see how you spin it that way, but you gotta see, you got a good son in a desperate situation trying to save his parents' house. He gets an opportunity to get $250,000 because y'all say, put a tattoo on and come get your money. Do you see how he got there?
I understand what you're saying, Your Honor, but he actually entered into an agreement with his tattoo artist. He had to have filled out some sort of document that said he was making this decision on his own.
How is that relevant, Your Honor?
We have no agreement with this gentleman to pay him this money in order to repay him for that
Your
tattoo.
Honor, doesn't the law say verbal is binding in advertising?
Representations in advertising can be binding, and verbal agreements can be binding. What they're trying to do right now is point to another guy. This happens all the time, including in lawsuits. And you go, it wasn't me, or I wasn't totally responsible. It's actually, well, the tattoo artist. I don't think this is a very strong argument. What do you think?
Yeah, not really. I mean, the tattoo artist is not involved in this at all. Whether or not this guy needed a tattoo artist to enter into the contest is kind of outside of the bounds of the terms that they stated on their website.
Well, there's a little more to it than that.
Thank you.
The law does hold you responsible for the representations that you make publicly. So whether verbal or written, you've got to be very careful about those representations. But why didn't you click on the little link on the bottom?
Your Honor, I missed that. It was too small for me to see.
So you never saw this second page?
Yes, sir, that's correct. I never saw that second page.
Mr. Bell, you are asking this court to award you $250,000 for your damages,
yes,
$10,000 for your future medicals, and $250,000 for pain and suffering. Now, you've told me about how the people reacted at the station when you went down there. What's the general public's reaction when you go around to some place like lunch or take your parents out to dinner or go to work?
In short, KRUD. I mean, Your Honor, there's been a laundry list of things how this has horribly negatively impacted my life. I lost my job because of this. My girlfriend broke up with me. My dating life's been a shambles. You know, I wanted to use this money to help save our home. And the biggest thing about it is the tattoo laser removal surgery that I'm going to need to have,
yes,
the
sir,
procedures. I can't afford that. And from what I understand, the research that I've done, it may not even be possible to remove all of this without scarring.
So in other words, the damages are not just financial, but pretty significant on the financial side. And I just go back to the piece that I heard was that this little advertisement, this website is not where this thing lived and died, meaning they were actively promoting this. So he's like, oh, this is interesting. And he called and he's looking into it. And then they directed him to the website. For me, that's the piece that makes the biggest difference.
Yeah, they're adding all of these extra people that are confirming this contract to him over and over again.
I was assured by someone at the station at the time that that was legit, and I've never seen any kind of contests or pranks that involved advertising money to anyone.
Your Honor, what he was told by our team member was, this is a legitimate contest that we're running. Go to the website to learn more. And he didn't follow the link.
We ran radio ads all the way up until April 1st, stating this was our biggest prank yet.
Let's listen to that ad.
It's coming, it's coming, it's coming! The craziest prank we've ever pulled is gonna hit you right between the eyes. Exclusively here at KRUD.
Well, Mr. Bell, did you hear that? If you're a regular listener,
That's right,
you would have heard that, right?
Well, see, Your Honor, one thing I probably should mention is I work for a telecommunications company. I work the graveyard shift. I just happened to be off that day that it happened, and like I said, I heard from a friend.
Yeah, but if they ran it all week and you are a loyal fan of Crazy Cyrus, why wouldn't you hear at least once?
That's a good question.
Your
Maybe they didn't run it as many times as they said they did.
Don't start that. Don't start.
Well, unless you have that evidence,
No, sir.
don't put that up. It's just more for me to get confused about.
I guess I'm getting confused. I'm like, what's the point of this prank then? Because they literally are advertising on the radio, so it was listened to, right? But at least from what we heard, it was advertised as a prank, so there was at least disclosure as to that. But I guess, why was this funny? I don't get it at all.
Yeah, let's say that nobody got the tattoo, then the prank wasn't successful, right? I mean, nobody got pranked. But then if somebody did get the tattoo, like happened, then somebody got pranked, it was a successful prank. Like, that doesn't really help them.
It almost sounds like they wanted to see if someone was, and I don't want to use the word dumb, but like dumb enough to go and get it, despite them telling the audience that this was a prank. But anyway, let's see what the judge does.
Folks, I think I have heard what I need to hear, and I am ready to render my decision. In every personal injury case, the plaintiff has to prove three things: that the wrong caused harm, Mr. Bell, you have put up evidence in this case that the radio station and Mr. Jones put out an advertisement that you get $250,000 to put the call letters on your head. Now, you were under some duress in trying to save your parents' home. That is a noble thing, and I understand why you did that. Now, you had certain responsibilities. You called the station to ask someone, is this real? You actually got on the website and saw the advertisement itself. But you did not click the little link in the corner that would have let you know that this was absolutely a prank. You all believe that had he clicked the link, he never would have had a tattoo on his head. And what he did was a stupid thing that you all should not have to pay for. In a fraud case, Mr. Bell has to prove that you all represented something that you knew wasn't true. You knew somebody was likely to rely on it, that person relies on it, and then they're harmed. In the evidence, there are two things that really bug me. The advertisement that has the link that confirms this is a prank, the page that he should have read is the second page, and he'd only find it if he read this small language at the bottom. The second thing is, you all are playing on people who are desperate. We live in desperate times. And the law says if you do a prank, that there's a high likelihood that someone's gonna do what you're enticing them to do. They do it and they are harmed. You're bad, but your bill, you must pay for that. And I find against the defendants, and in your favor, I'm gonna award $250,000 for your damages, $10,000 for your future medicals, $250,000 for pain and suffering, for a total award of $510,000.
All right, so look, if this happens to a business, you don't always win in litigation. So did they have insurance? This is going to make or break, truly, a business if they run into legal problems. And the judge really hit it on the head as far as the intentional misrepresentation. And they was kind of being mean. I think that's fair to say that they were looking for someone who was going to get confused by this to go and do it. Because otherwise, what was the point of the whole thing?
Exactly. They expected somebody to engage in this, to get this tattoo, so that they could ultimately make fun of them, right? I mean, it's a victim of the prank. And that insurance point that Crystal just mentioned is going to be so important, because how many businesses have $510,000 just lying around that they can throw at a court judgment? Not many.
So look, if you need help with all things terms of service, funny enough, we actually do represent a number of tattoo parlors. So we have experience on both sides of this kind of thing.
Yeah, we help people with this all the time. If you're looking to do something fun with your terms of service, if you want to do a program, maybe not a prank, maybe something a little bit more lighthearted, we'd love to help you make it legitimate. We'd love to help protect your business through it.
We're Delgado Entertainment Law. Don't forget to subscribe, and we'll see you on the next one.